Hello dear student, the act which we will discuss today with you, that is Arbitration and Conciliation Act 1996. This act has to be seen in the backdrop of huge pending cases across India in various courts, let it be at the district level or the high courts level or at the Supreme Court, because there are various cases, various disputes between the different parties which can be solved by either mediation or through arbitration, but they are pending in the court in the want of any such legislation. So the court has discussed, and in the government has decided in this part and they said that we can have an act that is known as Arbitration and Conciliation Act. Now this particular act provides alternative dispute redressal mechanism which may not be available otherwise. So when this particular act has come into the force, it has provided a basis for the parties, then they can settle their disputes with the help of arbitrator. It is not only provides a solution for speedy solution of the disputes, but also provides a mechanism whereby enmity between the two parties is also reduced. Because if you go to the courts, say for example civil courts, and then the case will be they linger on for at least 4 to 5 years or 3 years, you are going on the different dates, you are hiring your advocate, so the enmity level between the parties will increase. So that is why this act came into force. This act, Arbitration and Conciliation Act Conciliation Bill, was introduced in the Parliament in the 1995, but it was passed in 1996. However, earlier to this, arbitration was expanded to the three different laws. First, Arbitration Act 1940, Arbitration Protection and Convention Act 1937, Foreign Awards Act 1961. However, this present act, Arbitration and Conciliation Act 1996, has 86 cases and 3 sections and 3 schedules. Now these sections provide what is the definitions of which are used under this act, also provides various provisions for appointment of arbitrator, the proceedings in front of arbitrator, and how these proceedings shall be entertained by the court of law, how arbitrator can be appointed, what will be his role, how he will conduct the proceeding. Every provision related to all these things are provided. 3 schedule basically provides the matters and how these matters should be discussed or heard by the arbitrator in the court of arbitration are provided in these schedules. So the first part of it, the main definitions. Arbitration and Conciliation 96 basically provides for the word party, which is defined in the section 2 subsection 1 clause H, that party to an arbitration agreement means a person who involved in a dispute with some other person, and who has referred the case to the arbitration, and he is a party to such arbitration agreement. Section 8 of this act further provides the power of courts will be refers to the parties of arbitration. Then in the case of Sukanya Holding versus Jayesh Panda in 2003, Supreme Court held that every case, if possible, can be handed over to the arbitration and conciliation. Now any application by the non-signatory for the joinder to arbitration proceedings can be given. In this particular case, the Supreme Court held that there is no power conferred on the court to add the parties who are not party to the agreement proceeding. It means any party to the arbitration agreement can be only that party who is the party at the beginning of the dispute. When you file the complaint or when the matter is referred to the arbitration, no further parties can be added to this, unlike the courts. So there is nothing called joinder or rejoinder in the case of arbitration proceedings. Now, what are the background of this act and how does it come into the frame? It is the UNICITRAL, United Nations Commission on the International Trade Laws, who has adopted a model law in 1985 on the international commercial arbitration, where it was felt that any dispute at the international level can be solved through the arbitration. The General Assembly of the United Nations advised all the member countries to adopt this law so that the dispute between the parties and the confrontation can be reduced. The Law Commission in India has been asking for the change in existing law since very long. So after this particular convention which are adopted at the General Assembly of United Nations, this law was prepared. So these were the contexts, these were the references in which this new act, Arbitration and Conciliation Act 1996, was passed by the Parliament. Now I will discuss with you the provisions which relates to the arbitrator and how arbitrator can be appointed and how he will conduct the proceedings. Section 2 in this regard provides that arbitration award will include even an interim award. Arbitration tribunal means a sole arbitrator or panel of arbitrators. It means that it is not only the final decision of the arbitrator which has a binding on the parties, even their interim order, whatever the interim order they have given, that will also be a order of the arbitrator. An arbitrator tribunal or arbitration court will not only confine to one arbitrator, even in case more than one arbitrator or a panel of arbitrators have been chosen by the parties, then whole panel of arbitrators will be selected or recognized as the arbitrator board or arbitral tribunal by the courts. So I'm explaining you this example. Say for example, if there is a dispute between two publishers of your book. Say for example, you are having a book on the business law, which book is being published by two authors simultaneously. Now there is a dispute between these two parties, that who has the right to publish that book. Now in this case, if these parties choose an arbitration mode, then they can go to the arbitrator and they can appoint an arbitrator who will decide. Now in between, before the final decision is being taken by the arbitrator, either party can request the arbitrator that please issue the injunction order against Mr. X or Mr. Y to publish and distribute it into the market. So if even the arbitrator gives his decision on this, that will also be known as interim order, and that will also be the part of award only. The section 3 of the act provides that receipt of written communication means a proof of delivery to the party personally or at his place of the business, habitual residence or the mailing address. So in case any written communication which is received from or which is being made or delivered to either party on their address, usual address where they reside or which is given in that, or their office, place of business, then once it is delivered there, then it will be said as communication of the notice has been done to the parties. So it is deemed to have been delivered or received on the day it is delivered. So the day of receipt of the notice by the other party will be the day when it is delivered to that party. Then I am coming on the next point of it, that section 7 of the Act will provide that the arbitration agreement, it should be in writing as a separate agreement or part of contract signed by both the parties. So arbitration agreement has to be in writing between the parties. Now it may be contained in the earlier contract, or it can be entered by the parties separately after that contract. For example, I am giving an order, or I am entering into an agreement with the publisher that I want to publish my book on business law. However, that book is there. So if I have published that book and I ask my publisher that this agreement of publishing rights subject to the shall be subject to the arbitration and conciliation, not for the courts. So in that case, it is the agreement between me and the publisher in the beginning itself. But if I would have not entered, or I would have not have any clause like this in my agreement with that party, so later when some dispute arises, I can enter into an agreement that we want settlement through arbitration, and in this case both the parties has to sign the agreement. Section 10 of the Act further provides that the number of arbitrators will be decided by the parties themselves, but they shall be even in numbers. However, if the arbitrators are not decided by the parties, then arbitration tribunal shall consist of a single arbitrator. Practically what happens, that the list of arbitrator is available with the arbitration council at Delhi. It is at the FICCI, where the arbitration office is there, and there is a list of arbitrators. So if you yourself does not have any person to deal with your dispute, then you can go to them and select the name of the arbitrator who you feel that will suit for this particular work, and then that person will be a arbitrator. Now when you have more than one arbitrator, then there should be some chairman of the tribunal, a president of the tribunal. Now he should also be selected and agreed by the parties, because in the otherwise what will happen, that in case the decision is equally spreaded, then there cannot be any decision. So there must be a chairman or the president of the tribunal. So if the parties do not concur in the appointment, the court will make the appointment. So if you yourself cannot search an arbitrator, you can move to the court, and then the court of law will appoint the arbitrator. Generally what happens, if the dispute is there in the pending in the court and you want to settle it, you can request to the court that please refer the matter to the arbitration, and then the court will either you have to give the name of arbitrators, otherwise the court itself can provide you the arbitrator. The appointment of the arbitrator has to be made within 30 days from the receipt of the request to do so from the other party. So if this is not done, then the Chief Justice can be requested to make the appointments. So Chief Justice of the High Court, in case of the High Courts, the matter is pending there. In case it is a local, then even the district courts can provide the names of arbitrators. Now, how this arbitrator or failure and possibility to act. So section 14 of the Act provides that a person will cease. So in case any arbitrator who is either famous or is known that he will not be able to perform his duties well in time, or he fails to act without undue delay, or is related with the boss from his office, or both the parties to the agreement agrees to terminate his services as an arbitrator, or as a member of arbitral board. So basically any person can be there as arbitrator till he is accepted to both the parties to the dispute. The moment either party to the dispute has any objection, he cannot be an arbitrator. Section 19 of the Act provides that the determination of the rules and the procedure the parties are free to agree all the procedure to be followed by the arbiter, triangular or the tribunal sometime. Now when I say triangular, because sometimes the three are tribunal is being created. So if the parties wants that they can accept all the rules and procedures which are being adopted by the arbitrator. However, the arbitrator will have the same powers which civil courts have, which means they have the power to send the summons, it means notices, has the powers to call the witnesses on oath and to issue temporary or interim orders. The section 20 of the Acts will provide that place of arbitration. The parties to the contract or agreement are free to be agreed on the place of arbitration. So whatever the place they want, that will be the place where the arbitration proceedings can be conducted or initiated. However, if the parties cannot decide, then it is the arbitration triangular or arbitration tribunal that will decide that where the case will be discussed, and then they will decode it. Okay, so it is basically the courts or arbitration parties who are free to choose the place of arbitration. Otherwise, the parties to the contract fails to do, then by default it will be the arbitrators who will decide the place of arbitration. Then the section 21 of the Act will provide that the commencement of arbitration process, the arbitration proceedings in the respect of any dispute commencement on the date on which a request of arbitration is received by the respondent. So question is being answered that when the arbitration proceedings will start is given in the section 21, which says that when the arbitration request or a request regarding the settlement of any dispute through the arbitration is received by the opposite party, then it will be said that this proceedings has started or arbitration proceedings has started, because sending such letter will be deemed as an offer by the parties. Further, section 23 of the Act provides that a statement of the claim and defines the claimant shall state the facts supporting his claim within the period of time agreed upon by parties or by the arbitrator. So it means any claim or any defense or defiance even has to be submitted by the claim supporting his claim within an agreed period of time between the parties. Otherwise, whatever the arbitrator, based on the law of natural justice, decides shall be the time period for the arbitration. Section 25 the Act provides that default of a party means when any party fails to act according to the process given in the section 23. So when the arbitral tribunal terminate the proceedings, if the claimant fails to lodge his claim as given in the section 23, which is within the time period agreed by the parties or decided by the arbitrator. Now if the respondent will fail to communicate his statement of defense in accordance with the section 23, The arbitral tribunal shall continue the proceedings as if the allegation have been accepted by other party. So if you does not defy or you does not counter, any counter statement is not filed by you, then you shall be treated that you have accepted the allegations or the dispute made by other party. So once the notice is served and you have not answered to that fact, then the tribunal will fail that you have accepted the allegations which have been made on you by the claimant. So either you have to reply within the notice which is served on you within the time frame which is agreed by the parties or ordered by the arbitrator or arbitral tribunal. Otherwise, the court will entertain that you have accepted the allegations. So once any arbitration proceedings starts, the process of arbitration will be that a notice, a copy of the allegations submitted by the party will be sent to another party for their reply. Now that party has to give its reply, submit a defense within the time limit prescribed in the section 23 of the Act, which says that either the time limit agreed by the parties themselves or time period provided by the arbitrator, the reply shall be submitted within that time. If reply is not filed, then it will be known as that the parties has accepted the allegation, other party. After that, if the reply is being filed, in both the cases, the arbitrator tribunal will discuss the terms and conditions related to the contract, and then they will pass the judgment or award based on this. So whatever the arbitration is being made by the parties, the arbitral decision shall be final. However, in case either party to that arbitration agreement is not satisfied with the arbitration award, then they can appeal against the order in the court. Now, one more thing I will like to tell you, my dear, that Arbitration and Conciliation Act does not only deal with the domestic disputes, but it also provides the disputes settlement at the international transactions, which was the basic essence or basic theme when it was adopted at United Nations. Because the dispute at international level, say for example export and import or international trade, there you have a lot of disputes between the parties. Now these disputes cannot be settled by the courts because the laws in different countries are different. So here it is the arbitration which solve a very important purpose, and they provide the settlement to the arbitration disputes. Further, who can be arbitrator? Any person who is being accepted by both the parties, having the knowledge of dispute, can give decision or can act as arbitrator. However, in case any person who wants to get themselves registered as an arbitrator, then they can submit their CV. A person who has a knowledge of law and the commercial disputes can submit its name to the arbitration council, who will entertain that and will take him into the arbitration panel. So in case parties to the contract do not find themselves any person to act as an arbitrator, then they can move to arbitration council and can ask the name of arbitrator. So whatever the proceedings will take place in the arbitration court shall we have the same impact as the arbitration as the civil courts have. However, the order of the award by the arbitration can be challenged by the parties if they are not satisfied in the court of law. Now, my dear, I can summarize this lecture by saying that keeping in view the large number of cases which are pending in the courts of law in India at different levels, it has become the need of the hour today that there should be some legislation who can provide alternate grievance redressal mechanism or alternate dispute redressal. So this remedy was provided by this particular act, and this act does not only provide mechanisms for solving the dispute at the domestic disputes or domestic level dispute in India itself, but they also provide mechanisms to solve the international disputes also. So this is a very good step in order to bring the harmony between the parties and to reduce the litigation between the parties. Thanks, my dear. Thanks. I hope you understood what's the Arbitration Act overall and what are the different provisions of it. Thank you, my dear. Thanks.